Supreme Court, in the matter of SARANGA ANILKUMAR AGGARWAL versus BHAVESH DHIRAJLAL Seth, dismissed the appeals and directed appellant to comply with penalties imposed by National Consumer Dispute Redressal Commission within 8 weeks. The appeal had been filed against the final judgment and order passed by the National Consumer Disputes Redressal Commission, wherein multiple penalties, 27 in total, were imposed on the appellant for failing to deliver possession of residential units to home buyers as per the agreed timeline. Appellant sought a stay on the penalty proceedings before the NCDRC, contending application under Section 95 of the Insolvency and Bankruptcy Code 2016 had been filed against them, triggering an interim moratorium under the Section 96 of the IBC. This court is called upon to adjudicate whether execution proceedings under Section 27 of the Consumer Protection Act 1986 can also be stayed during an interim moratorium under Section 96 of the ABC, said Supreme Court. Court said that present case does not involve a mere financial dispute but concerns the enforcement of consumer rights through regulatory penalties. Given the legislative intent behind the Consumer Protection Act is to ensure compliance with consumer welfare measures, staying such penalties would be contrary to public policy. Further, appellant cannot invoke insolvency proceedings as a shield to evade statutory liabilities. Objective of the IBC is to provide a mechanism for resolving financial distress, not to nullify obligations arising under regulatory statutes. Supreme Court further held that the penalties imposed by NCDRC are regulatory in nature and do not constitute debt under the IBC. Moratorium under Section 96 of IBC does not extend to regulatory penalties imposed for non-compliance with consumer protection laws. Judicial precedents support the view that statutory penalties and regulatory actions do not automatically fall within the ambit of insolvency moratorium. In P. Mohanraj, the court held that a moratorium under Section 14 of IBC extends to proceedings under Section 138 of NI Act. However, a distinction between debt recovery proceedings and punitive actions need to be created, and therefore all criminal liabilities do not fall within the scope of moratorium unless explicitly covered under the IBC. Section 138 of Negotiable Instruments Act pertain to dishonor of checks and are criminal in nature, where the assumption of debt is inherent in the offense itself. The dishonor of a check indicates a failure to honor financial obligations, and proceedings are initiated for recovery of debt in question. In contrast, Section 27 of Consumer Protection Act deals with non-compliance with consumer protection orders, which are remedial in nature rather than criminal. Primary focus of proceedings under Section 27 of Consumer Protection Act is to enforce consumer rights and ensure that service providers fulfill their obligations. These proceedings do not assume the existence of financial debt but rather deal with deficiencies in service and failure to comply with consumer redressal mechanisms. Thus, the analogy drawn by the appellant between the moratorium on Section 138 NI Act proceedings and Section 27 CP Act proceedings is misconceived and legally untenable. If the appellant's argument is accepted, home buyers who have already suffered immense delays and financial hardship would be further deprived of relief. The legislative intent behind consumer protection laws is to safeguard the interests of consumers and ensure accountability from service providers. Permitting a stay on regulatory penalties under the guise of insolvency proceedings would undermine the very purpose of the Consumer Protection Act and embolden errant developers to escape liability through insolvency proceedings. Home buyers, many of whom invest their life savings in purchasing residential units, are already in a precarious position due to delays in possession and breaches of contractual obligation. Staying penalties that serve as a deterrence against such unfair practices would render consumer protection mechanisms ineffective and erode trust in the regulatory framework, said Supreme Court.